because part of the objective of this exercise is to develop a broader skill base to understand around some of the legal provisions in the FTAs dealing with digital. So what I have done in the PowerPoint I'm going to run through with you is extract out what have been seen as the core provisions and go through those with you to identify what some of the issues about them have been, including what some of the changes have been in some of the more recent agreements because of the issues that have been raised. And with a bit of luck, we should be able to knock it off in an hour, but stop as we go if there are things that you want to raise. Let me share screen, bring that fellow up, and okay. So just a little bit of context, because I mean, I don't know that Vanessa was a part of the last discussion, or if you haven't seen the intro thing. So it's worth going back and getting a bit of a sense of the context, because it helps make sense of the rules. The evolution of what started off being called electronic commerce chapters and then digital trade rules really goes back to the later 1990s, when, of course, the World Wide Web and the internet had burst onto the scene. Not that many people really understood it, but Silicon Valley was especially interested in getting an expansion of what was the rules regime under the US Telecommunications Act, which was a regime that provided for regulation of the telcos, because that was at a time when they were being broken up into what became known as the baby bells. And the Telecommunications Act basically said, and we agree not to regulate the internet. And so what the Silicon Valley companies in particular wanted was to lock that in, not just for the US, but to lock it in as the global rules. And so we started to see in the late 1990s some moves, quite embryonic moves in some of the US FTAs, but also in the World Trade Organization in 1998, the launch of a work program on electronic commerce. And that was not terribly detailed and was going to be operated through the bodies of the World Trade Organization that deal with different sets of rules. So the council that dealt with trade in goods, the council that dealt with trade in services, the council that dealt with intellectual property rights, and the Committee for Trade and Development. And so 1998, that came onto the agenda along with something that is very controversial at present, and we're probably not going to go into much today, which was a moratorium on customs duties or tariffs on electronic transmissions. And this was at a time when we were just starting to see the likes of Amazon and so on delivering across the border hard copies of things, but we were also just starting to see the digitization of hard copies into soft forms. And what the tech companies wanted was not to have the equivalent of the tariffs or customs duties that applied to hard products applying to the digitized products. So in 1998, we had those two developments as part of the work program. And the work program has limped on, and the moratorium that was temporary has been renewed every couple of years at the Ministerial Conference of the World Trade Organization and comes up again in February in Abu Dhabi. And developing countries are wanting to get rid of it because it's now eroding their tariff revenues, and developed countries, including New Zealand, are wanting to lock it in and make it permanent. And they're doing that in some of their free trade agreements as well. So that's where we started in the later 1990s. Then we get to 2010, when we have the launch of what become the Trans-Pacific Partnership Agreement, or TPPA negotiations. And that is the first of the agreements that contained detailed rules on what was called electronic commerce, which went way beyond anything specifically about commerce and was largely a set of rules about how the parties could regulate or not regulate the digital domain. And so the TPPA was the first major negotiation with an e-commerce chapter, and the successor version of the TPPA, once the US was pulled out by Trump, the CPTPP, retained the same rules. Since then, other agreements have followed and expanded on that template. So some of them have been bilateral between Singapore and Australia, who have become champions of these rules. The US-Mexico-Canada agreement, which is the successor to the NAFTA, the North America Free Trade Agreement, has more expansive rules, but also claws a couple of things back. The EU FTAs, again, as we saw with the New Zealand one, has very similar rules, but reflects the EU's, I was going to say preoccupation, the EU's very strong privacy approach. We have the Digital Economic Partnership Agreement, which New Zealand championed along with several other CPTPP countries, but which includes some inclusiveness and other provisions alongside the CPTPP ones. So we've seen an expansion of that original TPPA text, but we've also been seeing, especially in recent times, increasing dissension over those rules. And so in the Regional Comprehensive Economic Partnership Agreement, the one with the ASEAN countries and South Korea and Japan and Australia and New Zealand and China, we have seen a couple of the rules dropped out and the chapter is not enforceable. In the current Indo-Pacific Economic Framework negotiations, the IPEF, Pillar 1 of that, the trade pillar, has digital trade. It's known in the public domain that the original text that the US tabled was very like the TPPA template, etc. But more recently, because of disagreements in the Congress over the need to break up the big tech companies and so on, the some of those rules, especially around data and so on, have been basically taken off the table. And then at the World Trade Organization, there has been a plurilateral negotiation on e-commerce that was launched after the Buenos Aires ministerial in 2017. The latest leaked text of that from 4th of August this year showed quite broad disagreements over the core rules. So that's a kind of potted evolution of what's been happening in the digital trade e-commerce space. But of course, New Zealand as an original signatory to the TPPA CPTPP has those very specific rules that were a part of the original US-driven template. And that was what the Y2522 Waitangi Tribunal inquiry looked into and found was a breach of the Crown's obligations under Te Tiriti. So it's now going to be interesting to see what happens with the review of the CPTPP that's currently underway. The TPPA was an incredibly successful venture for the big tech companies. The lead negotiator, Robert Holliman, had spent 23 years as the president of the Business Software Alliance in the US, which meant basically the digital industry was negotiating the agreement. And it was based on what is referred to, and it's on the USTR's website, the Digital 24 Principles, which was the wish list from big tech. And the key rules in that wish list were a free and open internet, i.e. an unrestricted internet, no digital customs duties, as I explained before, non-discrimination so that there was a level playing field, although of course a level playing field where big tech are the dominant players is not very level, unimpeded ability to move data across borders, no localization barriers that required data to be held in countries, no forced technology transfers, protection of source code from requirements to disclose, ability to use technologies of choice, fostering innovative encryption, market-driven standardization and interoperability, robust commitments on cross-border digital services, on market access and non-discrimination, right of the affected companies to participate in the development of any new regulations and standards, strong IP protections, and enforceable consumer protections, but with no threshold. So that was basically the wish list that was carried into the text of the TPPA. And that was what was taken before the Waitangi Tribunal and which led to the tribunal seeking some kind of balance that in pursuing negotiations, the Crown needed to actively protect Māori rights, interests and responsibilities, not just be concerned with advancing Māori business and exporters' interests, that provisions such as provisions on movement of data have been adopted with minimal or no consideration of Māori rights and interests guaranteed in Te Tiriti, and that the tribunal was not convinced that relying on the exceptions and exclusions in the agreement, including the Treaty of Waitangi exception, would be sufficient to provide that active protection. So that was right at the very beginning of these rules, and the Crown has, unfortunately, the report didn't come out until the negotiations for most of the existing agreements were well underway. So against that context, I want to have a look at some of the rules themselves, but are there any questions about that, kind of how things came about and the evolution? Oh, okay. I suppose I should ask how familiar any of you are with what these chapters actually kind of look like. And I've lost you all. I can't see you all. So can I have a kind of a 1 to 5 of how familiar you are with what these kind of chapters might look like? 1 is fine. I just need to know.
Yeah, probably.
This is a 1.
Right.
I'm probably, middle 3.
Okay.
I
Clary?
would say a 1.
Cool. Carrie? Okay. The first thing we always find in these chapters is that it sets out the scope. And I should say that I'm focusing here on the chapter called e-commerce and digital trade. There are other chapters that are also relevant, and I'm going to refer to one of them. For the most part, I'm going to look at the e-commerce digital trade chapter. So the chapter has rules, and the rules set out obligations. And most of those obligations we refer to as disciplines on a party. So they're not conferring rights on a party as much as conferring obligations. That means they have to discuss what is the scope of those obligations. And for most of the regulatory chapters that we find in these agreements, the scope is very broad. So the scope applies to measures. And a measure can be a law, a regulation, an administrative rule, an administrative procedure, a decision, a policy about a subsidy, or anything else. So basically anything that a government does that is adopted or maintained, so that exists at the time the agreement enters into force, or that is adopted subsequently by a party, and by a party, the party includes sub-central levels of government. So in a federal system, the state or the provinces; in our system, a local government; or where there is a delegated authority by the government, the entity exercising that delegated authority. Which, were we to be looking at authority being delegated to some Māori entities, would capture those entities. In some chapters, it will apply at all those levels across the board. In some of them, the sub-central government obligation will apply with the obligation that the central government takes all steps reasonably available to it to ensure compliance. So we've got measures that are the broad things governments do that exist or adopted later by a party at different levels of government that affect trade by electronic means. So they may not be directed at it, but if they have an effect on trade by electronic means, then, for example, the adoption of a new privacy law that may not be specifically directed at the digital, but would have an effect on the operation of digital transactions, then it would be captured. It does not apply, kind of, to government procurement, but for reasons I'm not going to go into here, but I'm happy to if someone wants to at a later stage. It's not clear whether government procurement applies only to the process of procuring or applies to the content of the procurement contract as well. And the chapter does not apply to information held or processed by or on behalf of the government. So, for example, census data wouldn't be included, or tax data. But health data, which might be a mixture of private health data and public health data, is arguably outside that exception or that carve-out. So we're looking at a pretty broad spectrum of measures that governments might adopt that could have an effect on what's described as trade by electronic means, which basically means digital transactions involving a supplier of one party and a consumer of another. And then there's a very complicated crossover to the cross-border services chapter that I'm not going to go into, but I can tell you that I've been working on trade and services since 1990, and I struggle to be able to apply that provision and make any confident predictions about what the rules are. So that's the scope. And then in the chapter, we have different kinds of rules. They deal with different sets of issues. So what I've just been describing are kind of the general provisions, set out the definitions and the scope and the principles. Then there's what could be considered to be genuine tradey rules. Things that are designed to facilitate trade as we used to know it. So having customs processes that are paperless to allow the use of e-signatures as opposed to requiring physical signatures. E-authentication, which is, for example, when you have that double check, they send you on your mobile a second tier identification number that you have to put into the transaction. Right? So that's one section of the kind of rules that we have. A second category of rules are the ones that are super, super important to the tech companies, which are dealing with their right to control data. Given that data is at the core of everything digital And the more data they have and the more that freedom they have to deal with it, the more power they have with their algorithms, AI, and so on, but also the more dominance of the market they have. And so the two core rules on data location, or what they call data localization, a prohibition on rules that say you can't take the data offshore, including in some recent agreements that you can't require the data, a copy of the data, to be held in your country. And I'm going to show you some text on that shortly. And allied to that, a prohibition on rules that say you must use local servers, you must hold your data on local servers. And there are some provisos to that, and we're going to have a look at those in a moment. I'm just going through the categories of what you find in the chapter at this stage. Then there's a category around digital regulation. Privacy and consumers, which we'll see is basically you have to have rules on them, but there's no threshold on what they have to say. Spam, of rights of consumers to opt out. Rules on cryptography, which has become increasingly important with the likes of WhatsApp and so on. Rules around regulatory frameworks and around transparency, by which they mean the right of affected companies to have a say about the adoption of new rules. Then we have a set of rules dealing with security. National security exception, which tends to be very broad. Cyber security, which tends to be just talking about cooperating. We have rules on revenue. We have the one I described on the moratorium on customs duties on e-transmissions. We have in some agreements, some provisions on tax, but a tax on digital transactions, or what's sometimes called a digital services tax, that Labor just introduced shortly before the election at 3% of gross revenue for digital companies above a threshold. That would be a measure affecting trade, a measure affecting the supply of trade by electronic means. And then there are some institutional arrangements, a committee that would establish, that would run the chapter, provisions on cooperation, provisions on future negotiations. So it's a pretty sweeping set of rules in terms of how it potentially impacts on the domestic regulatory space of governments. So if we go through the core rules that you can't restrict data transfer offshore, that you can't require data is held in the source country, that you can't require offshore providers have a local presence, so they're under the jurisdiction. You can't require, if they do have a local presence, that they have a legal form of the kind that would be subject to the jurisdiction and to penalties. You can't require the disclosure of source codes or algorithms as a condition of providing a product or a service that contains them. You can't require the use of local content, which includes, for developing countries, important issues about digital startups and so on, but also cultural content and so on. You can't discriminate between local and foreign tech firms, so you can't adopt rules that are targeted to try to break up the power of the big oligopolies. You can't hold online platforms liable for third-party content. So all of those issues we've had around the Christchurch call, etc., but also things like the posting of on Viagogo, the fraudulent tickets, or the dreadfully culturally abusive shower curtains with tā moko and so on. You can't require the employment of locals if they would access proprietary knowledge of the tech companies. You can't cap cross-border royalty payments in related party contracts. So the likes of Uber that would have a very small domestic operation, the money goes out of the country, goes to one space, then gets transferred off to another tax haven and so on. And it's usually done through cross-border royalty payments, which Lynelle will be very familiar with. There were moves by some countries to try to cap those royalty payments for related party contracts. You can't do that in some of the agreements. You can't require technology transfer, no tariffs on e-transmissions, and requiring prior consultation before introducing measures. So let's just have a look at a handful of the provisions. The most important are these data localization provisions. And we have a very familiar device that's used in trade agreements. The first paragraph says the parties recognise each party may have its own regulatory requirements concerning the transfer of information by electronic means. But of course, having your own regulatory requirements does not mean that you have an open choice as to what those regulatory requirements are. They are subject to the rules that follow. And the rules that follow, each party must allow the cross-border transfer of information by electronic means, including personal information, if this activity is for the conduct of the business of a covered person. So if you have an entity that is covered by the chapter, it has to, whether it's a finance operator or an advertiser or an engineering company or an education company or a telemedicine provider or a tourism operator, they have to, or Facebook, they have to be able to take the data out of the country. Now that's the UK one. That's very like the TPPA. And the twin to that is that neither party shall require a covered person to use or locate computing facilities in its territory as a condition for conducting business in that territory. So a computing facility is largely a server, maybe some other technologies or hardware, but is predominantly about can't require them to use a server in the country. So we've got Microsoft or some of the other tech companies now starting up servers in Aotearoa. Even though they may be their servers, you couldn't require them to hold the data here rather than take the data offshore. Of course, that makes it much harder if we're looking at Māori data sovereignty to be able to exercise any control over that data. There is, and this is the TPPA language as well, a third provision. Nothing shall prevent a party from adopting or maintaining a measure inconsistent with paragraph 2, that is, about moving the data or requiring it to be held here, to achieve a legitimate public policy objective, not defined, and therefore potentially challengeable. In the WTO current text, the EU has got a footnote saying, for greater certainty, privacy provisions are a legitimate public policy objective. So one can't take for granted what any of them might be. But it is subject to two other conditions. One of those conditions is that the measure you adopt or you keep to achieve the legitimate public policy objective is not applied in a way that would constitute arbitrary or unjustifiable discrimination. And the US has claimed in some of its Section 301 investigations on digital that anything that affects disproportionately its big tech companies is unjustifiable discrimination, or would constitute a disguised restriction on trade, i.e. would have the effect of benefiting your own suppliers of that service. Which, if we're looking at Māori data provisions, Māori data sovereignty provisions, the likelihood is that it would be would constitute a means of giving preferences to local suppliers of data-related services, and then you have an argument about whether it's a disguised restriction or not. But the next one is the more problematic one, in that it doesn't impose restrictions that are greater than required to achieve the policy objective. And the US view of that is that a voluntary compliance measure is a legitimate measure and is the preferable approach that should be taken, rather than an obligation that is in law or that carries consequences. And so when we were arguing this in the Waitangi Tribunal, the tribunal actually agreed that there was a risk that measures that were adopted for the purpose of complying with Māori obligation to Māori under Te Tiriti to provide active protection for rights in relation and responsibilities in relation to taonga, to data as taonga, would not necessarily be protected by this. The EU FTA, I should go back and check. Are you with me? Vanessa?
Ka pai, Jane. It's all good.
Oh, tēnā pai, you were a number one. That's why I'm asking you.
Thank you.
So we have a variation on that in the EU one. Whoopsie. Because the UK one and the TPPA one, while you can't restrict them taking the data offshore, and you can't require them to use a server onshore, arguably you could still require them to keep a copy onshore and still be able to take the data offshore. The EU's approach makes that more difficult, and it combines those two provisions into one. So parties are committed to ensuring cross-border data flows to facilitate trade in the digital economy and recognise each party may have its own regulatory requirements. Again, doesn't say much. To that end, a party shall not restrict cross-border data flows between the parties in the context of activity that's within the scope of this chapter. Shall not do it by requiring the use of computing facilities or network elements in its territory for data processing, including by requiring the use of computing facilities or network elements that are certified or approved in the territory. Not requiring localization of data in the territory, so not even a copy. Prohibiting the storage or processing of data in the territory of the other party. Making the cross-border transfer of data contingent on the use of computing facilities or network elements or upon localization requirements in its territory. So every possible angle there is covered. So when we're looking at what kind of limitations there might be on that, we need to look at several of the other provisions in the chapter, because one of the big issues around data is, of course, the privacy provision. One of the issues in the 2522 claim was that Western concepts of privacy that are about individual persons' privacy as an identifiable person are a very limited subset of concepts of collective privacy that relate to Māori data, including data that is intrinsically containing whakapapa and that carries with it responsibilities on the individual for what consequences there might be of what use is made of their personal data for others who might be affected by the use of that data. When we come to the trade agreements, we see it's a very narrow definition of personal information about an identified or identifiable natural person. So their argument is even anonymized information, depersonalized information that might be used for the development of algorithms does not fall under this personal information protection provision. But it certainly doesn't cover the broader conceptions of privacy, which some of the UN rapporteurs have been developing in the context of the UN Declaration on the Rights of Indigenous Peoples. Hello, Kat. So what do they say needs to happen about personal information protection, even in this narrow sense? Each party shall adopt or maintain a legal framework that provides for the protection of that kind of personal information of the users of digital trade. In the development of its legal framework, each party shall take into account principles and guidelines of relevant international bodies. So taking into account is an obligation, you have to do it, but you don't have to then incorporate those in. You have to have reflected on them when you have developed your legal framework. And then in the UK one, it sets out the parties recognise the principles underpinning a robust framework include, and then there's a list. So you'll note in that there is no threshold. There is no requirement that the legal framework meets a minimum standard. And that's because this reflects the TPPA approach, and of course the US has very minimal privacy provisions. Oh, okay. All right, I thought I'd put in the EU one, but it looks like I haven't. The EU one is a little bit stronger because it has the GDPR, and it requires countries that are a party to agreements with it to have some degree of equivalence to the kind of protections that it has within the EU for privacy. A next really important provision that the tech companies wanted was to go beyond what is in the intellectual property chapters of these agreements about protecting their trade secrets to protecting the source codes of the software in the products that they're providing or the software itself. And the reason why they went beyond the IP chapter is, firstly, there are some limitations in the IP chapter on trade secrets that they wanted to bypass, as it was explained to us by one of the negotiators. But also the kind of discipline that they were looking for here wasn't just an intellectual property right protection. So if you think about, let's use the example of Tesla. I know it's not an American. Oh, yes, it is. Let's take Tesla. There's been a case recently that Tesla's dial that tells you how much further you can drive on the charge that you've got in the battery was deliberately misleading. And people were told that they had much more distance than in fact they did. If you were wanting to prove fraud, or you were wanting to at least prove consumer malpractice towards consumers, you would need to be able to have access to the software. This was designed to stop you being able to require the transfer of or provision of access to the source code of software as a condition for the import, distribution, sale, or use of that software or products that contained it. And of course, there's all sorts of other, there's the television sets that can spy on you and all sorts of other things. So those issues have become more important subsequently. But the original rule in the TPPA was that you could not require the transfer of or access by parties to the source code as a condition for allowing the software or products to come into your territory. That was limited to mass market software and products, which would have been the motor vehicles and the television sets and so on. Not software used for critical infrastructure, such as water infrastructure or electricity infrastructure and so on. But the main exception that was in the original was to allow a party to require the modification of source code of software where that was necessary to comply with the laws or regulations of the party, provided those laws and regulations were not inconsistent with the agreement. Now, if that hurts your brain, that's fine. Basically, the laws and regulations had to already be what the TPPA would allow you to adopt, and you could require the modification of a source code where that was necessary to comply with the laws or regulations that the agreement allowed you to have. The problem was, how did you prove that there was a breach if you couldn't gain access to the source code to conduct an investigation? So being able to require a modification as a remedy was kind of beside the point, because you needed to have access to the source code in most instances to be able to show that there was a problem. So we did manage to at least get negotiators to agree that that was a problem. We haven't gone back and fixed it in TPPA yet. But in the EU FTA, for example, there's a variation on that. Parties recognise the increasing social and economic importance of the use of digital technologies and the importance of safe and responsible development and use of such technologies, including in respect of source code of software. And that's consistent with some of the new digital services legislation that's been introduced in the EU. So what they've now put in there is a party shall not require the transfer of or access to source code of software owned by a party as a condition for the import, export, distribution, sale, etc. from its territory. But nothing in this article shall affect the right of regulatory authorities, law enforcement, judicial or conformity assessment bodies of a party to access source code of software prior to or following import, export, distribution, etc., to determine compliance with its laws and regulations, including those relating to non-discrimination and prevention of bias, subject to safeguards against unauthorised disclosure of it. So in the Waitangi Tribunal, part of what was argued about source codes was that source codes and the algorithms that they that are related to the source codes have been shown by research to be racially biased, to be involved in profiling, to have adverse consequences, that you need to have access to the source code to be able to identify and expose. Now, in some later agreements like the USMCA, they explicitly also say including the algorithms contained in the source codes. It's ambiguous here whether algorithms are covered or not. And so this is an example of one of the changes that was brought about by some of the arguments in the tribunal and in other places. But the difficulty still is that you need to have enough of a prima facie understanding that there's a problem to then be able to demand access to the source code to be able to undertake the investigation. There is also a problem that the safeguards against unauthorized disclosure means that it wouldn't be able to be academics and tech experts and so on outside government who would be able to do that investigation. That's how, for example, the Tesla frauds were recently discovered. Another source code issue, of course, has been the anti-competitive practices of the big tech companies, which is now covered in B of the EU FTA. Nothing in this article shall affect requirements by a competition authority to remedy a violation of competition law. So A would allow an investigation of anti-competitive practices, including things like squeezing out SMEs because we're told that SMEs, including Māori small businesses, will be able to do wonderful things on Amazon and so on. But we know that they're down on page 10. And there's been lots of competition law cases against the tech companies for own brands and so on. And so competition authorities or relevant bodies may be able to require remedies that assumes still that you can bring them under your jurisdiction, which is not necessarily that easy. So let me just check in with you again. So that's the two main rules there, the data localization rules about transfer offshore and use of local facilities, and the source code provisions. And the very limited privacy protections are quite critical to these chapters. Carrie, did I see a nod? Or kind of a nod? No. Any questions, comments?
Jane, it's Vanessa.
Yeah.
I've got one question that I don't see anywhere, and I know it's a trade chapter, so maybe that's why I don't see it. When you talk about remedies, is there no moral obligation?
There's no morality in these things.
No. So that's my first one. My second one is, how do the trade chapters deal with other conventions? So in the context of the Budapest Convention, is there some rider that the Budapest Convention could override some of the aspects of any of the trade agreements, or does it just get dealt with separately on a case-by-case basis?
Now, there's no, unless it's explicitly mentioned, this is effectively a code.
Yeah.
Right? So, and to go back to your first question, which I answered a little bit too quickly, there is an exception that we will kind of come to, although I'm not sure I put it on the PowerPoint, known as the general exception, which allows countries to take action that is necessary for public morals, or necessary for public order. And we have a couple of problems with that about kind of what would be considered to be public morals. Then we have necessary, and necessary means, is it the least burdensome to achieve the objective, similar to that earlier provision. And it's subject to the chapeau that this can't be constitute arbitrary or unjustifiable discrimination or a disguised preference for your domestics. And in the WTO, where that's been relied on as a defense, it has succeeded fully only 2 out of 49 times for the whole of the exception. And that includes for environmental purposes, health purposes, and so on. So it's a very, very difficult threshold to meet. And you have to argue it as a defense. So it's not something that protects you from a dispute being brought. It's something that you would have to respond to a dispute. If they showed that you'd breached the rules, you would then have to show, yes, but I'm covered by this defense. And one of the arguments in the Y2522 claim was what we call the chilling effect. That if there is a potential risk that's identified in these rules, it may deter a government from adopting a measure that it fears might be challenged. Yeah?
Mm-hmm. Kapai, thank you.
Now, kia ora, Annette, I see you're on. Kia ora. Okay, so let's have a look at another.
I am listening, but I just had 3 decisions from the Court of Appeal and the High Court, so I'm reading those. Well, I am
Did you
listening.
win?
Okay, kia ora.
Kia ora. This will bring back happy memories for you about what we had to argue in the tribunal. So this next provision is not actually in the digital trade chapter. It's in the chapter on cross-border services. And I want to explain a little bit about that chapter because I talked before about the digital trade or the e-commerce chapter as being new and being driven by those digital 24 principles that Big Tech put together. Well before that, there were rules about how governments can or cannot regulate services. The supply of a service by a provider from one country and a consumer by another, which would include the supply of a tech service, supply of a digital marketplace, supply of a fintech service, supply of a telemedicine service, supply of a search engine. And one of the ways that those services can be traded is if the foreign supplier of the service comes and sets up an investment in your country. But another way is that they could stay in their country and you could be the digital consumer in Aotearoa and the service, if you like, crosses the border. So that's called cross-border trade and services and is basically dealing with digital and digitalized services. And so what the tech companies want, logically, is not to have to set up in every country some presence. They want to be able to operate out of hubs, take all their data back to those hubs, be subject to the digital governance regime in those hubs, which they're often chosen for being minimalist regulatory regimes. And so this rule on local presence is that the party shall not require the service supplier of the other party to establish or maintain a representative office or any form of enterprise or be present in person or have a local company in the territory as a condition of supplying the service. So it can supply the service from outside the country without having to have any presence in the country. Now, some of you might remember the Viagogo situation. Remember Viagogo, the clearinghouse for entertainment and sports tickets and so on, lots of fraudulent tickets on the website. Viagogo is a Swiss company, has no presence in Aotearoa. The Commerce Commission got lots of complaints. It wanted to have an interim injunction to stop Viagogo doing those things. Viagogo said, not our responsibility, what's up on there, we're not responsible for third-party content, and in any case, we're not subject to your jurisdiction. So for the Commerce Commission to even serve the papers on Viagogo, it had to go through diplomatic channels to be able to serve the documents in Switzerland. Then there were lots of legal arguments about whether the Swiss company was even subject to New Zealand law and so on. And there were similar proceedings in Australia and so on. Now, that's just one example of, you can imagine all sorts of situations involving Māori, where there might be action that you might want to take, and how do you actually get to the entities that are responsible. So this is in this cross-border services chapter. It has this rule on local presence, not requiring a local presence. The services chapters have these annexes to them. And the annexes allow a government to, there are two annexes. One allows a government to say, well, these are existing rules that we have that are not compliant with the rules in this chapter, and we want to keep them. If we change them, if we remove them, then okay, we accept that we give them away forever, but we want to keep the ones that we've got that are in existence now. But of course, when we're dealing with digital issues that are evolving so rapidly and new situations that aren't thought of and so on, and if we're dealing with the fact that there's no protections for Māori in terms of a Māori digital governance framework, then it's a question of keeping the policy space open to introduce something in the future. And that's what the second annex is supposed to be about. But despite us arguing about this, in the UK FTA, for example, there is no protection of that kind. All there is one that allows New Zealand in the future to adopt or to keep it if it exists now, measures in respect of cultural heritage of national value, including ethnological, archaeological, historical, literary, artistic, technological heritage, and collections, and museums, and galleries, and libraries, and heritage, and public archives, and historical and sacred sites. But nothing in there about Ngā Tauranga in its broader sense, nothing there about whakapapa, and we didn't get very far in arguing with them that they needed to change that, because they've had this one in there for several decades, and they get stuck on saying if we adopt something new, then that implies the previous one isn't adequate, and therefore we're not going to change it. So the local presence rule is another potential issue. What happens if there's a breach of these rules? And I'm going to get to a couple of other exceptions in a moment. If there's an allegation of a breach, there is to be consultation between the governments that are a party to the agreement. If it's not resolved, then the complaining state can refer the dispute to a panel, but the judges on the panels are trade experts. So if you're looking at a legitimate public policy objective through the lens of a trade expert, and you're looking at the protection of whakapapa, firstly, they're not going to understand what whakapapa is, but they will then have to work out, for example, was there a less burdensome approach to achieve protection of whakapapa than the one that the Crown adopted? So one of the arguments we used in the tribunal was that these are totally inappropriate entities to be empowered to carry out those kinds of judgments. So it gets to this trade panel, and the complainant state has to show that one of those rules or other rules I haven't dealt with you have been breached. And Aotearoa would have to show that there's an exception that applies. If it fails to do that and the breach is found, then either it has to withdraw the measure that is in breach, well, it has to withdraw the measure that's in breach. They don't always do that, and they don't always do it immediately. And so until it does so, there can be sanctions against New Zealand's exports to the value of what the complainant's firms say they are losing by that breach. So you can imagine that if it was New Zealand service suppliers who were being punished, it might be some impact on New Zealand consultancy firms or whatever, but more likely the complainant state would seek to impose sanctions against something that would really hurt New Zealand, like butter or lamb or some commodity. So these, unlike rules in other international agreements, these rules can have teeth. And the fact that there are lots of vaguenesses, if that's a word, around the rules creates a real risk, especially if the kind of innovations that are being proposed, such as innovations to implement Te Tiriti o Waitangi or obligations, other obligations to Māori, we can't guarantee that a government is, especially an incoming government of the kind we're going to have, is going to hold the line. So, a couple of additional things that the Crown might fall back on if there was a dispute. The first and obvious one is the Treaty of Waitangi exception, which has been rolled over since 2001. And which the Waitangi Tribunal agreed would not, even with all the other protections, be guaranteed to provide effective active protection for Māori in the sphere of Māori data sovereignty and digital governance. So what does this exception say? Well, it starts off with that language that we call the chapeau, right? Provided that such measures are not used as a means of arbitrary or unjustified discrimination or as a disguised restriction on trade in goods, trade in services and investment. So we've got that proviso that sits in the background. Nothing in this agreement shall preclude the New Zealand government from adopting measures it deems necessary, so self-judging for the Crown as to what it deems is necessary, but it's to accord more favourable treatment to Māori in respect of matters covered by the agreement, including fulfilment of its obligations under Te Tiriti o Waitangi, the Treaty of Waitangi. So there are three problems we have in that first provision. The first is we have that chapeau about arbitrary and justified discrimination and disguised restriction on trade. The second is it relies on the Crown to deem something as necessary, not Māori to deem something as necessary. And thirdly, it only applies to more favourable treatment to Māori. And in trade agreements, more favourable treatment carries a meaning of positive discrimination. So it's possible, and we conceded this in the tribunal, that a requirement on a tech operator in Aotearoa to use some Māori apps, that could be seen as more favourable treatment to Māori because it is giving them favourable treatment across general suppliers of apps. But if it was when we are going to require a local presence of a foreign operator providing certain kinds of services in Aotearoa, so it is subject to our laws, that's not positive discrimination in favour of Māori. That's a kind of that's a generalised non-application of a rule. Or for Māori, for protection of collective privacy. Is a collective privacy rule more favourable treatment to Māori, i.e. positive discrimination in favour of Māori, or is it a different kind of regulatory approach? Likewise, is requiring disclosure of a source code to be able to identify racial bias, including in facial recognition software and so on. Is that more favourable treatment to Māori? Or is it finding a way to apply New Zealand laws that apply to Māori and apply to others as well, in breach of that source code obligation in the UK agreement and TPPA? So there's a whole lot of fishhooks in that treaty exception. Then part 2 of paragraph 2 says that in interpreting Te Tiriti and the treaty, including rights and obligations on it, the dispute settlement provision shall not apply, but the dispute settlement provision shall apply to other things, such as that chapeau about arbitrary or unjustified discrimination and disguised restrictions on trade, and shall apply to whether this is more favourable treatment. So it's only the interpretation of Te Tiriti and the rights under it that are not subject to the dispute process. So the tribunal agreed that this was not, even with those other legitimate public policy provisions and so on, going to provide effective protection for Māori. It was too late to do anything about that in the UK FTA, but the EU FTA, the tribunal report came out about 4 months before the negotiations were concluded. And so the pressure came on the Crown as to how to provide protections for Māori that were more effective than those that the tribunal said had failed the test. And so in the EU New Zealand FTA digital trade chapter, there is right at the beginning of the chapter, which is where the scope of the chapter is defined. That is, it sets out what the chapter covers and doesn't cover. It says this chapter does not cover measures that exist or adopted in the future by New Zealand that the government deems necessary to protect Māori rights, interests, duties and responsibilities, footnote, which includes those relating to Ngā Tauranga Māori, in respect of matters covered by this chapter, including in fulfilment of New Zealand's obligations under Te Tiriti o Waitangi, except it's still got the chapeau in it about arbitrary or unjustified discrimination or disguised restriction on trade. So what this did was shift the burden to someone wanting to complain, a government wanting to complain, the EU wanting to complain that New Zealand had breached one of the rules in the chapter by adopting measures to protect or promote Māori rights, interests, duties and responsibilities, including in relation to Ngā Tauranga. It shifted that to what we call a carve-out from the chapter. So if the EU was complaining, the EU would have to show that this carve-out didn't apply. So the burden would be on the EU right at the beginning to show that this exclusion carve-out didn't apply, which means it would basically need to rely on that chapeau, that it was used as a means of arbitrary or unjustified discrimination against persons of the EU, or a disguised restriction on trade enabled by electronic means. So it was about an 80% protection over what was there in previous agreements. However, it didn't solve the problem of the local presence rule in the cross-border services chapter. So it was a step forward. It was a step forward that required the EU to agree to it. And the EU only agreed at the very end. It was one of the very last things to be agreed to. And it required some political leverage from the New Zealand end to get there, which does at least show that MFAT took it seriously. Oh. I'm not quite sure what was not in that previous one. In addition to that, because they couldn't get a protection written into the UK FTA, because it was too last minute and the UK wouldn't agree, they got a review provision put in. Now, normally these agreements and specific chapters have a provision that there will be a review within X period of time of the chapter. And usually that's with a view to making it more liberalized. However, this review provision is a bit different because it recognizes that there is nervousness around these digital trade rules. So this is the UK review provision. To take into account developments in digital trade, the parties shall review the operation and implementation of this chapter and the financial data and information provision in the financial services chapter within 2 years of it coming into force, unless they agree otherwise. So it's now come into force and we've got a couple of years to before it comes up again. In the context of that review, and following the release of the Y2522 report at the end of 2021, New Zealand reaffirms its continued ability to support and promote Māori interests under this agreement. Well, that's not kind of do anything. But it affirms its intention to engage Māori to ensure the review in 2 years' time takes account of the continued need for New Zealand to support Māori to exercise their rights and interests and meet the Crown's responsibilities under Te Tiriti o Waitangi, the Treaty of Waitangi. And they stuck in there, and its principles, despite the fact it wasn't meant to be in there. But that means there is a potential for a fight over when that review is occurring in a couple of years' time, for whatever provisions might be sought to provide better protection for Māori. And in the EU FTA review provision, the parties shall keep the implementation of this article under review and assess its functioning within 3 years after the date of entry into force of this agreement, unless they agree otherwise. And this is the review of the data provisions. A party may also at any time propose to the other party to review this provision, and that shall be accorded sympathetic consideration. Doesn't mean you're going to get there. But in the context of this review, following the release of the 2522 report, New Zealand again reaffirms and affirms its intention to ensure the review takes into account . So that also means that in the EU FTA, within 3 years of entry into force, there can be a review of the data provisions. So the 2522 report has had some impact. The empty provision that was there, which somehow I didn't seem to have filled in, was what is happening in the World Trade Organization e-commerce provisions, which has the most effective protection proposed so far, because it has a similar protection to the one that is in the EU FTA, but it doesn't have that chapeau. It doesn't have the issue around disguised trade restrictions, etc. At present, no one is supporting it, and it may be a lonely fight. There have been questions asked about it in the WTO negotiations on e-commerce, and Ngā Toki Whakarururanga has played a role in providing the answers that the Crown has provided to that. But we do have a whole raft of other negotiations that are currently underway as well, where similar fights to keep the policy and regulatory space open in terms of treaty compliant digital frameworks apply. And so what Ngā Toki Whakarururanga is doing is, in response to this, there are a number of pānui that have been developed as educational resources on digital trade and FTAs that are about to be rolling out. There are these online webinars. There's planning for some kind of hui to discuss a strategy around this, which will be a small hui of those who are engaged in this space. But there is a plan to co-host with the Data Iwi Leaders Group a hui for Māori on data sovereignty and digital trade agreements early next year. And we are aiming after that to finally get the Crown and Māori into a hui to debate this kaupapa so that there can not be an agreement by agreement battle every time there's a negotiation, and there is a very clear kaupapa that the Crown has to follow. So that's it